Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning, focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to talk to you about what you should do immediately after a loved one dies and you realize that there is a probate that is necessary. But before I do, I wanted to invite you to schedule a free strategy session with me at eldermeeting.com. Okay, so I frequently get calls from relatives or people who know that they've been named as the executor of the person or the personal representative of their loved one or their friend's estate. Usually the person was terminal for a period of time and they finally passed, and they feel this urgency to start to do the winding up of the affairs and opening up of a probate. And so they start calling around to attorneys and having all kinds of questions, and they just want to know what to do. And so usually my advice to them is to take a pulse, take a breather, because you've just experienced a major life event, right? Even if you knew that it was imminent and it was coming, the fact that it came, it can cause you to have a great deal of stress and grief, and not everybody works efficiently in it, and other people just really need to find purposeful work, so working towards the probate is something that they put their time at. So I just ask them to take a breath and acknowledge what they're experiencing and do what they need to do, but at their pace, right? Like, you don't need to overwork yourself to exhaustion to try to figure out the next step. However, I do want people to have kind of a checklist, a task list, if they do want to start the process and find that they want to get to it right away. And one of the things I do is make sure that you secure the will or the trust if they have one, right? Another thing to do is to monitor the mail. Because you'll need to be putting creditors on notice, and you'll want to know what bills were owed, and also what type of bank accounts or investment accounts your loved one had. And how we can do that is, if some people leave you a great organized binder of their life, other people don't, right? And so how we figure that out is who sends you a bank statement to the house, okay? And this gets trickier when people these days do more online banking and things of that nature, but many times there still be some sort of quarterly, annual, report, something that's mailed. So you just want to monitor the mail. And then just slowly make your way through any of where they keep their important papers, and just get a pulse as to what the estate consists of, right? Is it exempt assets, non-exempt assets? You'll sort through that. Meaning, is it a homestead is the primary legacy, or is it is there a vehicle involved? Or is there a fleet of vehicles? What is it? So you want to do that, and then once you're kind of organized and you have a general pulse as to what the debts are versus what the assets are, then you can decide if you are opening your probate right away, or if you want to, you can discuss with your probate attorney a strategy to wait and not open your probate right away if you feel that the debts greatly exceed the amounts that's in the estate. Meaning, opening a probate today, we would just be essentially paying off all bills and probably not even paying everybody in full, and the heirs would get nothing. There is a strategy that some people like to engage in, that they prefer in an effort to protect their loved one's legacy and keep some assets in the family, and that is to wait and not open a probate until after the statute of limitations period has told on creditor claims. There's 2 years. A creditor, anybody that your loved one owed money to, can open the probate. It doesn't have to be the family. And so sometimes families will say, gosh, I really don't need this money. I don't need title to that, rental property or whatever it is that they thought that they needed. They don't need it right away. They don't need it for the next 24 months. And so they will strategically hold off on opening the probate in an effort to see if any creditors feel the need to open the probate, and should after 24 months of passing nobody has opened the probate, then the family will open a probate, and at that time all the creditor claims have been barred, and so those monies do not need to be repaid back because they are time barred, and the legacy of their loved one can pass to the relatives or to the people that they named in their will. So that is a strategy that some people engage in. Other people think that that's inappropriate and they should pay the bills. It's a personal decision. Like I said, it's a strategic move. It's not for everybody, but some people find that to be helpful and in preserving their family legacy and ensuring that their loved ones' desires are met. If this video has been helpful to you, I ask that you like and share with others. And as always, you can schedule a free strategy session with me at eldermeeting.com. Thank you for joining me.